Okay, so let's go to the next topic. Article 1526. Okay, it's about a lien on the goods or right to retain them for the price where he is in possession of them. In case of insolvency of the buyer, a right of stopping the goods in transit after he has parted with the possession of them, and a right of resale as limited by this title, and a right of rescind the sale as likewise limited by this title. Where the ownership in the goods is not passed to the buyer, the unpaid seller has, in addition to his other remedies, a right of withholding delivery similar to and coextensive with his rights of lien and stoppage in transit to where the ownership has passed to the buyer. Okay, so Article 1526, the ownership in the goods may have passed to the buyer, the unpaid seller of goods. Okay, unpaid seller of goods has a lien on the goods or right to retain them. Lien, yes, there's an encumbrance, okay, over the goods, okay, has a right, has a title over uh, the goods while he is still in possession of them. In case of insolvency of the buyer, a right of stopping the goods in transit. So at the time while the goods are still in transit and the seller was able to obtain knowledge or has gained knowledge or learned that the buyer is already insolvent, he has the right to stop, okay, the delivery of the goods in transit. It's also the right to resale as limited, okay. So the seller also has the right to resale and the right to rescind the sale as likewise limited by this title, where the ownership in the goods is not passed to the buyer. Okay, the unpaid seller has, in addition to his other remedies, a right of withholding delivery similar to and coextensive with his rights of lien and stoppage in transit to. So he or she shall has the right to stop, okay, or withhold the goods. Okay, special remedies of unpaid seller of goods. It gives the unpaid seller of goods certain remedies, but they do not cover an action for the purchase price. Even if the ownership in the goods is already passed to the buyer, the unpaid seller may exercise the following rights. Okay, under Article 1527 to 29, a lien on the goods or right to retain them for the price while in his possession. In 1530, a right of stopping the goods in transit to in case of insolvency. A right of resale under Article 1533. A right to rescind the sale under Article 1534. If the unpaid seller still retains ownership in the goods, he cannot be said to have a lien on his goods. But he does have, in addition to his other remedies, right of withholding the delivery. Okay. So nature of unpaid seller's possessory lien on the goods, the right given by this article, though denominated as a lien, is in truth greater than a lien. The seller's position is very nearly that of a pledgee with power to sell at private sale in case of default, because he or she has the right to resale as well. And the power survives till payment of the price. Unless you pay, I will have the right to resell. Okay? Unless you pay, I will have the right over these goods. An action for the price is not inconsistent with the latter's enforcement of the lien, though the buyer must be credited with any payment of the price in reduction of the lien. The possessory lien, referred to in 1527 to 1529, should be distinguished from preferred claim or lien as provided in civil code. The possessory lien entitles the seller to retain possession of the goods as security for the purchase price. The seller is saying, I will not be releasing this until I see that money coming out of your pocket and given to me. Where the goods are in the possession of the buyer, the seller has no more possessory lien. Wala na because it's already delivered, no? But his claim for the unpaid price is a preferred claim or lien. He or she has now the right to demand for the price because it has already been delivered and there is no more possession on the part of the seller. Of course, because it's already delivered, the possession is now in the buyer. Simply stated, upon delivery, the seller's possessory lien on the goods is lost. Wala na. But his lien on the price remains. Meaning, he can compel now the buyer to actually pay the price. Okay, what are the basis of the rights of the unpaid seller? The ground upon which an unpaid seller is allowed a lien and kindred remedies is the inherent injustice of depriving him of goods which he has not finally parted, where it is evident that he has not been or will not be paid the price for them when it is due, like in the example when the buyer has become insolvent. The same principle of justice is applicable in every case where a possessor of goods is entitled to receive a price on the surrender of the goods. Accordingly, the term unpaid seller has a wider meaning than the literal language would import. In 1527, again, as we've discussed, where the goods have been sold without any stipulation as to credit, where the goods have been sold on credit but the term of credit has expired, and where the goods becomes insolvent, when the buyer becomes insolvent, the seller may exercise his right of lien, notwithstanding that he is in possession of the goods as agent or bailey for the buyer. Pwede niyang hindi na i-release. Okay? So, when unpaid seller's possessory lien may be exercised. 1. Without stipulation as to credit. 2. Upon expiration of term of credit. Or at the knowledge of the insolvency of the buyer. I'd say knowledge of the insolvency of the buyer because you cannot exercise this pursuant to insolvency of the buyer had you not obtained knowledge of the insolvency of the buyer. So again, in a credit sale, the seller binds himself to give the goods over to the buyer without receiving at the time payment for them. Where there is a stipulation as to credit, a period for payment of the price has been fixed in the contract. But if there is no stipulation of credit, of course, she has the right to possessory lien, meaning I can still possess the goods insofar as at the time when you are able to provide me with a purchase price because there is no stipulation as to credit. Even it's a different story if we have agreed to a credit. I should part with my goods and give it to you, okay, at the time, okay, agreed upon, even without the money or the purchase price being received yet because there is a stipulation of credit. But if there is no stipulation of credit, I should have a right to withhold, okay, a possessory lien over my goods. And expiration of term of credit, even where the parties agree upon a credit, and the seller's right of lien may be exercised. By the nature of the credit sale, the buyer is entitled to possession of the goods without paying the price. But if he fails to exercise his right until the term of credit has expired and the price becomes due, he loses the right which he thereto had. So he could have had the goods ahead of time without paying. But if he failed to exercise his right to obtain possession of the goods prior to the payment, and now the credit has expired, he no longer be able to compel the seller to release the goods because the seller now, pursuant to the expiration of term of credit, can have the possessory lien over the goods. And of course, the insolvency of the buyer. The insolvency of the buyer is another situation where the lien of the seller in possession is revived even though the time for payment of the price has not yet arrived. So you cannot say as the buyer that, hey, we have not agreed on paying ahead of time, even if the payment term or the time of payment has not yet arrived, for as long as I have knowledge as the seller of the goods that you are already insolvent. Okay? This doctrine is only an application of a general principle in the law of contracts that when one party to a bilateral contract is incapacitated by reason of insolvency in this case from performing his part of the agreement, the other party also is excused from performing. Okay? It should be noticed that insolvency does not dissolve the bargain. It merely revives the seller's lien. So the moment that your circumstances could change, you could then obtain possession of the goods. I can release it to you because I could then rely that you will be able to fulfill your part of the bilateral contract. Okay? So that is the principle, guiding principle there. Okay. So as to unpaid seller as bailey for the buyer, it is immaterial that the seller holds the goods as bailey for the buyer. Of course, it's immaterial because I am the seller, right? So indeed, this always is the situation where the seller's lien is in question. For the property having passed, the seller is necessarily holding the buyer's goods and therefore acting as bailiff for him. Of course naman, di ba? And uh, had there been no issues at all, I could just treat myself as really the bailiff, holding the goods, taking care of it like a good father of a family if there is no other stipulations in the law where it is required to have other diligence, okay, other form of diligence, no? And though he's charged the buyer storage for the goods, the lien may still be asserted. Okay. So what about Article 1528, where an unpaid seller has, okay, unpaid seller has made part delivery of the goods, he may exercise his right of lien on the remainder. So I will no longer deliver the remainder of the goods because of this, okay? So unless such part delivery has been made under such circumstances as to show an intent to waive the lien or right of retention. So lien generally not lost by part delivery. So I can still withhold as to the remainder of the goods. However, if the delivery of the part is intended as symbolic delivery of the whole, and therefore a waiver of any right of retention as to the remainder, the lien is lost. But it's hard to establish really. The intent to make such waiver may be inferred from circumstances. So, titingnan natin yung entire story. As to Article 1529, the unpaid seller of goods loses his lien thereon when he delivers the goods to a carrier or other bailiff for the purpose of transmission to the buyer without reserving the ownership in the goods or right to the possession thereof, meaning it passes the ownership at the time of the shipment. When the buyer or his agent lawfully obtains possession of the goods, of course, nakuha na ni buyer, by waiver thereof, kung he waived retention of the ownership, and the unpaid seller of goods having a lien thereon does not lose his lien by reason only that he has obtained judgment or decree for the price of the goods. Even if I have already obtained judgment or decree for the price of the goods, I still have the right to possessory lien, okay, of the goods. When unpaid seller loses possessory lien, delivery to agent or bailiff buyer, possession by buyer or his agent, and waiver of the lien. All these cases, the transfer has already been done. Okay. Revival of lien after delivery. If the buyer refuses to receive the goods after they have been delivered to a carrier or other bailiff on his behalf, though the seller has parted with both the ownership and possession, he may reclaim the goods and revest himself with his lien. Timing, no? Nag-deny naman si buyer to accept. So, if he refuses to receive, then I retain my right to possessory lien. Likewise, if the buyer returns the goods in wrongful repudiation of the sale, the lien is revived. Of course, kung sinuli mo sa akin yung goods, then I now have the right to retain them. Okay? Subject, of course, for you to comply with your end of the bargain, meaning you pay the price as agreed. In Article 1530, subject to provisions of this title, when the buyer of goods or is becomes insolvent, the unpaid seller who has parted with the possession of the goods has the right of stopping them in transitu. He may resume possession of the goods at the time while they are in transit, and he will become entitled to the same rights in regard to goods as he would have had if he had never parted with the possession. So basta at the time nag-transit pa, he was able to recover his possession by notifying or stopping the shipment, he retains or he reverts the ownership to him and possession to him, and therefore he has the right to lien. Okay, the right of seller of goods in transit, he can stop the transit. Okay, goods are on the way. While on the way, you can stop. Okay, requisites, the seller must be unpaid, the buyer must be insolvent, the goods must be in transit, the seller must either actually take possession of the goods sold or give notice of his claim to the carrier or the person in possession, and the seller must surrender the negotiable document of title, if any, issued by the carrier or bailiff, and the seller must bear the expenses of delivery of the goods after the exercise of the right. So, syempre, magbabayad ka pa rin kay carrier. Dahil kahit hindi mo pinapush yung pag-deliver, nag-effort na sila, di ba? So, kung nag-effort na, magbabayad ka pa rin ulit kung saan ipapa-deliver because you are stopping it from the delivery to the buyer. Basis and nature of right of stoppage in transit. The essential basis really is the injustice of allowing the buyer to acquire ownership and possession of the goods when he has not paid, and owing to his insolvency cannot pay the price which has to be given in return for the goods. In other words, the fundamental basis of the right is the far-reaching principle allowing rescission and rescission where there is actual or prospective failure of consideration. Actual or prospective failure. Actual when the goods can be delivered and can no longer be paid, or prospective because you know that the buyer is insolvent. This right does not proceed from any agreement of the parties but is independently conferred by law. It may be regarded as a legal extension of unpaid seller's lien. Okay? What about Article 1531? Goods are in transit within the meaning of the preceding article in 1530. From the time when they are delivered to a carrier by land, water, or air, or other bailey for the purpose of transmission to the buyer until the buyer or his agent in that behalf takes delivery of them from such carrier or other bailey. If the goods are rejected by the buyer and the carrier or other bailey continues in possession of them, even if the seller has refused to receive them back, that is still in transit. So goods are no longer in transit within the meaning of the preceding article if the buyer or his agent in that behalf obtains delivery of the goods before their arrival at the appointed destination, and if after the arrival of the goods at the appointed destination, the carrier or other bailey acknowledges to the buyer or his agent that he holds the goods on his behalf and continues in possession of them as bailey for the buyer or his agent. And it is immaterial that further destination for the goods may have been indicated by the buyer. If the carrier or other bailey wrongfully refuses to deliver the goods to the buyer or his agent in that behalf, if the goods are delivered to a ship, freight, train, truck, or airplane chartered by the buyer, it is a question depending on the circumstances of the particular case, whether they are in possession of the carrier as such or as agent of the buyer. If as agent of the buyer, then the goods are no longer in transit. It has already been transferred to the buyer. And the carrier has become an agent or as bailey for in behalf of the buyer. If part delivery of the goods has been made to the buyer or his agent in that behalf, the remainder of the goods may be stopped in transit. Okay? Unless such part delivery has been under such circumstances as to show an agreement with the buyer to give up possession of the whole goods. So these are the goods when in transit after delivery to a carrier, okay, and before the buyer or his agent takes delivery of them, and if the goods are rejected by the buyer and the carrier or other bidder continues in possession of them. When goods are considered no longer in transit, ito yon, as I've described in 1531 here, ito yon, okay, after delivery to the buyer or his agent in that behalf, if the buyer or his agent obtains possession of the goods, if the carrier or bailey acknowledges to hold the goods on behalf of the buyer, and if the carrier or bailey wrongfully refuses to deliver the goods to the buyer. So, what are the effects of refusal of carrier to or deliver the goods? The carrier is not allowed to enlarge the seller's right by wrongfully refusing to deliver or return the buyer's agent. But a rightful refusal by the carrier based on, for instance, on the refusal of the buyer or his agent to pay the freight will not terminate the right to stop. Okay? Delivery to a ship, etc., are chartered or owned by buyer. This case, the possession is now transferred to the buyer. Chartered by the buyer, the mere fact that the carrier is chartered by the buyer does not make a delivery to the carrier a delivery to the buyer. Whether delivery to a carrier chartered by buyer means possession by the carrier as such or possession by the carrier as agent of the buyer, in which case the goods are no longer in transit. It's a question depending on the circumstances of the particular case. If owned by the buyer as delivered to an agent other than one whose only duty is to forward the goods, is a delivery to the principal. Delivery to the buyer's servant who is under a general duty to obey his master's order is necessarily a delivery to the buyer. Hence, delivery to a vessel belonging to the buyer is delivery to the buyer. So the difference, chartered and owned. Chartered, not a delivery to the buyer. Owned by the buyer, delivery to the buyer. What's the difference between chartered and owned? Chartered, nagbayad siya on his behalf and parang um, I am commissioning this vessel to pick up the goods and deliver it to me. That's chartering the pipe. Okay, chartering the vessel, okay, the carrier or the ship. While owned by the buyer, siya yung may-ari mismo ng vessel or the ship. Effect of partial delivery. The mere fact that part of the goods has been delivered does not deprive the seller of the right to stop with respect to the remainders, just as the seller may still exercise his right of lien on the remainder after part of the goods had been delivered. However, it may be shown that the seller has an agreement with the buyer to give up possession of the whole goods. In such a case, he cannot uh, he cannot affect the provisions as to lien, possessory lien, because there was already an agreement to give up possession of the whole goods. Okay, how about 1532? The unpaid seller may exercise his right of stoppage in transit either by obtaining actual possession of the goods or by giving notice or claim to the carrier. So, dalawa yan eh. Kung you still have actual possession of the goods, of course, you still have possessory lien because it's still in your possession. Another possessory lien that you can effect is when you notify the carrier to stop. Okay? Give notice that you are going to take possession of the goods. Okay? So, ways of exercising the right to stop. The seller may exercise the right of stoppage in transit either by taking actual possession or by giving notice of his claim to the carrier. Okay, to make notice effective as a stoppage in transit, it must be given at such time and under such circumstances that the principal, by the exercise of reasonable diligence, may communicate it to his agent to prevent the delivery to the buyer. There is no form of notice which is essential. It is only necessary that the goods be sufficiently described for identification. Okay, but to be safe, really, if it's like LBC, there is a tracking number. You know what item you have shipped out. Just give them the tracking number. It should be specific enough to describe the identity of the shipment that you are trying to stop to give enough notice. No? Of course, if you have obtained actual possession, that gives you way better standing in your possessory lien. Okay. Effect of outstanding bill of lading. If the goods are covered by a negotiable document of title, like the bill of lading, the carrier or bailee has no obligation to deliver the goods to the seller unless such document is first surrendered for cancellation. Malamang, di ba? Bigay mo rin sa amin yung document of title. Okay? Because the bill of lading will be given to you at the time when you have given possession to the carrier. So when the carrier returns to the goods, of course, they have to obtain the document of title. Should the carrier surrender the goods to the seller and afterwards the bill of lading be negotiated to an innocent purchaser of value, the latter would be entitled to demand delivery of the goods. Yun lang. The only way in which the carrier can be assured that no subsequent purchaser can arise is by requiring a surrender of the document of title. Yan yung iniiwasan. Because remember, if it's a negotiable document of title and you as the bailee does not require the seller to return that document of title, paano kung binenta niya na yun, di ba? Nakuha niya yung goods niya dahil sa kanya nga naman talaga yun, siya yung nagpa-ship. But at the same time, kung binenta niya yun, he also was enriched unjustly, di ba? Because he or she obtained a consideration to depart from that document. Tapos hindi mo ni-require. So later on, pagka may nag-claim ng document na yon, he can compel you as the bailee na, bigyan mo sa akin yung goods. Nandun yun dito sa bill of lading. So as the one who actually holds the goods, you ask the seller to surrender the bill of lading. Sige, sulit ko na sa iyo. Sabi mo, stop ko na tong delivery. So, ibigay ko to sa iyo. You will obtain possession of the goods. But at the same time, bigyan mo rin sa akin yung bill of lading. So that it makes me confident enough and it assures me that there is no further purchaser of the document of title. Remember, a document of title can be transferred, diba? It's negotiable by the word itself. It can be endorsed, can be negotiated, and therefore, a third party could actually obtain it in good faith. Okay? The right of the purchaser for value in good faith to whom such document has been negotiated is superior to the seller's unpaid lien or stoppage in transit, even when such purchaser acquired the same after notice of stoppage was given by the seller to the carrier. It has no bearing at all. Okay? So about 1533, where the goods are perishable nature, or where the seller expressly reserves the right of resale in case the buyer should make default. Siyempre kasi this one is perishable, so pagka nagkasira-sira, magka-delay ng isang buwan, kung gagawin, di ba? So where the buyer has been in default in the payment of the price for an unreasonable time, an unpaid seller having a right of lien or having stopped the goods in transit may resell the goods. That's one of the rights that we've mentioned earlier. Okay? So, unpaid seller's right of resale when the resale allowable. Okay? Where the goods are perishable in nature, where the right to resell is expressly reserved in case the buyer should make a default, and where the buyer delays in payment of the price for unreasonable time. Okay? An unpaid seller can exercise the right to resell. Okay? Only when he has either a right of lien or a right to stop the goods in transit. Okay? Under any of the three cases. Effects of resale. The seller is not liable for any profit made by such resale, but if he sells for less than the price, he has a right to sue for the balance as against the original buyer, and the new buyer acquires a good title to the good. So this is tricky, and you should remember this one. So this case, if the seller, okay, for as long as this the provisions of this article applies, meaning he or she has a right of lien or has stopped the goods in transit, he has the right to resell. Now, when he resells, he can sell it at a higher price, at a lower price. Okay? Or really, he needs to resell it. Why? Because this is the case of perishable goods. Okay? This is perishable goods in Article 1533. Now, if it's a perishable goods, time is of the essence in reselling. Diba? Kailangan ko nang mabenta yan. Kailangan na yung ma-consume. It's consumable, it's perishable. Otherwise, it will rot. And then, it will have no value at all. So, I have to resell it. Good if I can resell it. Say, if the item or the goods is really scarce, that a lot of demand is there in the market, I can easily resell it and even at a higher price. And if I resell it at a higher price, I am not liable to the buyer for the profit from the original buyer's price. So if I am supposed to sell it to the original buyer at 100 and I was able to sell it at 120 and I was able to gain a profit of 20,000, that 20,000 goes to me. Okay? But if it is sold, say, it was supposed to be like 100 per item for 100,000, and then due to your inability to fulfill your end of the bargain as original buyer, I will have to resell it because I have the right, possessory lien, and I have the right to resell, exercise my right, and then I was only able to sell it at 80,000. I lost 20,000. Then I will be able to sue the original buyer, okay, for the 20,000 damages. Okay, that is the importance here. Next, notice of resale is not essential, meaning the seller's right to resell the goods for the buyer's account may depend to some extent upon the length of time the buyer has been in default. A notice by the seller of his intention to resell may operate to fix the time within which it is reasonable that the buyer should perform his obligations. That, except in the case of perishable goods, which it is obvious may require an expeditious sale, and where the right to resell is reserved, the failure to give notice shall be relevant. But generally, no, unless it is specified. Okay? Manner of resale. Any absolute rule requiring the formality of an auction sale might bear harshly on the seller in case where the goods are of small value and the buyer is financially responsible. The law is satisfied with a fair sale made in good faith according to the established business methods with no attempt to take advantage of the vendee. The seller is only required to exercise reasonable care and judgment in making a resale. Okay? He cannot, however, directly or indirectly buy the goods. Wag naman na 100,000 yung supposed na ng buyer tapos ako na lang din bibiling ko siya ng 10,000 and then I will sue you for 90,000 tapos later on ibibenta ko na yun kasi nabili ko na yun, ibibenta ko yun at a higher price. Wag naman ganun. Okay, that's what it's saying here. In Article 1534, an unpaid seller having the right of lien or having stopped the goods in transit may rescind the transfer of title and resume the ownership in the goods. Okay, so when the seller may rescind, okay, the fourth right of an unpaid seller is the right to rescind the seller. An unpaid seller has a right to rescind only if he has either a right of lien or a right to stop the goods in transit. Either of the two situations where the right to rescind is expressly reserved in case the buyers should make a default or where the buyer delays in the payment of the price for an unreasonable time. Okay? Masyado nang matagal ang paghihintay. Effect of rescission. In the case of rescission, the seller resumes ownership in the goods. Okay? As if the sale did not happen. While the seller shall not be liable to the buyer upon the contract of sale, the latter, however, may be made liable to the seller for damages for any loss occasioned by the breach of contract. If you did not fulfill, there is breach of contract, then I may sue for damages. Manner of rescission. An election by the seller to rescind may be manifested by notice to the buyer or by some other overt act showing an intention to rescind. Communication of such election to the buyer is not necessary. Hindi kita kailangan i-inform. Okay? But as in regard to resale, the giving or failure to give notice is relevant in determining the reasonableness of the time given the buyer to make good his obligation under the contract. So kapag nag-resell ka, especially kapag mag-sue ka rin for the lesser amount na nakuha mo and then you will sue for damages, at least establish that you have actually made notice to the buyer, original buyer, na hey, mag-fulfill ka na, tapos nag-refuse siya, and then tapos hindi niya pa rin makomply yung obligations niya in relation to the contract of sale, then you are good as far as notice is concerned. Okay? What about Article 1535? Okay? The unpaid seller's right of lien or stoppage in transit is not affected by any sale or other disposition of the goods which the buyer may have made unless the seller has assented thereto. So for as long as I have no knowledge or hindi ko naman pinagbigyan yan, naibenta mo na dahil hindi po nga bayad yan, it should not take effect on my right of lien or stoppage. So hindi ako pwedeng sabihan ni buyer na, oy, hindi mo na pwedeng i-stop yung shipment kasi naibenta ko na yan. No, it doesn't bear any effect on me. Problema mo yan. Why? Because I did not assent, I did not give my consent for you to sell it or resell it. Okay? In the first place, you have not obtained possession over it and you have not even paid for it tapos binibenta mo na, di ba? Unless, of course, it's a different story kung sinabi mo sa akin na, hoy, I will buy this tapos ibibenta ko to sa ganito kong buyer or customer ha. O agreed ka dito ha, ibibenta ko na to, wala nang bawian. Kung nagsabi kang okay, yes, dahil confident ka tapos biglang nag-iba yung ihip ng hangin, then you will be bound by your word or by your agreement there too. Otherwise, it will not affect, okay, your right of lien or stoppage. Okay? Article 1536, the vendor is not bound to deliver the thing sold in case the vendee should lose the right to make use of the term as provided in the Article 1198. The right of vendor to withhold delivery in sale of credit. Okay. So, in a contract of sale, the obligation to pay the price is correlative to the obligation to deliver the thing sold. Accordingly, the vendor is not bound to make delivery if the vendee has not paid him the price. However, if the period is fixed for payment, the vendor must deliver the thing sold to the price be not first paid. Kasi nag-agree ka naman, okay, that will be paid at a later date. Fixed na for the payment. But even if the vendee was given the benefit of a period, the vendor may not be compelled to make delivery in case the vendee, yung buyer, should lose the right to make use of them. Ano yung the right to make use of them? The right to make use of the period, okay, arises. And you still remember this in your obligations and contract? And such vendee has not yet paid the price. Okay? Do you still remember this in your obligations and contracts? When can the obligo, when does the debtor ceases to enjoy the right to a period? Okay? So, the debtor, to, sa obligations and contracts nyo to, this is your review na, siguro dito, no? The debtor shall lose every right to make use of the period. When after the obligation has been contracted, he becomes insolvent. Okay? Yun yung sinasabi natin. Unless he gives a guarantee or security for the debt. Or when he does not furnish, kung nagbigay siya ng security previously or guarantee tapos na-impair yung value nun or the loss yun, not to furnish, he does not furnish the creditor the guarantee or security or the guarantee or security has been lost. Pwede din yan. Or when the debtor violates any undertaking in consideration of which the creditor agreed to the period and the debtor or vendee attempts to abscond. May pagtatangkang lumayas or takasan ng obligasyon. So if that's the case at na-discover yan, you will lose the right to enjoy the period. And therefore, babalik ngayon dun sa case na the seller has the right to retain or the lien over the goods. Okay? Okay. 1537, the vendor is bound to deliver the thing sold and its accessions and accessories in the condition in which they were upon the perfection of the contract. Okay? All the fruits shall pertain to the vendee from the day on which the contract was perfected. From that contract was perfected is the operative word there. Okay? So yung fruits dapat ma-deliver. Any fruits born after the perfection of the contract shall necessarily be delivered to the vendee. Okay? The vendor is bound to deliver the thing sold and its accessions and accessories. Okay? In the condition in which they were upon the perfection of the contract. Okay, dito siguro the importance is for you to actually know what accessions are. These are fruits of a thing or additions to or improvements upon a thing such as the young of animals, house, or trees on a land. Accessories are anything attached to a principal thing for its completion, ornament, or better use such as picture frame, keys of a house, etc. Okay? So Article 1538, in case of loss, deterioration, or improvement of the thing before its delivery, the rules in 1189 shall be observed, the vendor being considered a debtor. So again, this is in relation to your obligations and contracts na naman, no? In case of loss, okay, deterioration or improvement, na-discuss to in your obligations and contracts under Article 1189. Okay, so the rules, if the thing is lost without the default of the debtor, the obligation shall be extinguished. Sinabi natin yan, di ba? If the thing sold is lost through the fault of the debtor, he shall be obliged to pay damages. It is understood that the thing is lost when it perishes, or goes out of commerce, or it disappears in such a way that its existence is unknown, or it cannot be recovered. When the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor, obviously. But if it deteriorates through the fault of the debtor, the creditor may choose between rescission of the obligation and its fulfillment. With, of course, indemnity for either case. Okay? Damages. Basta merong fault, damages. Remember that. If the thing is improved by its nature or by time, the improvement shall inure to the benefit of the creditor. If it is improved at the expense of the debtor, he shall have no other right than the granted to the usufructuary. So ito, kung hindi ka nag-effort at nag-improve yung thing that you are supposed to deliver, whatever is the improvement is due to be given to the creditor. Okay? Is due to be delivered to the vendee, to the buyer. Kasi ikaw yung may possession nun. Sir, paano naman kung nag-improve yung thing dahil sa mga nagastos ko or in-improve ko siya kasi gusto ko talaga din siyang maganda pag deliver ko. While you are in the possession of that, sabi ng batas, you were enjoying the thing. Your usufructuary rights over that thing. That is your benefit. Ibig sabihin, you are not entitled to reimbursement. Okay? Let's look at examples. Okay? S sold to B his car. If before delivery, okay, of the sold to be his car, if before delivery the car is lost without the fault of S, assuming S is not guilty of any delay and there is no contrary stipulation that he shall be liable, the obligation to deliver is extinguished, and B shall be obliged to pay the price if he has not paid the same. Ito yung masaklap, di ba? Nag-agree na kayo, there was already executed a contract, tapos nagpirmahan na kayo. Wala pang delivery nangyari of the car. Tapos hindi naman nakaspecify kung kailan mo siya i-deliver. Hindi pa naman nag-lapse yung reasonable time of delivery. So you are not at fault. Tapos biglang nagkaroon ng calamity at na-destroy yung car and it's totally rendered wrecked and 100% hindi na siya magagamit. Lost na yung car pero perfected na yung contract. Who will bear the loss? It will be borne by the buyer. So ngayon, si seller can now compel you to pay the price kung hindi mo pa nabayaran. Kung nabayaran mo na, hindi na isusulit ni seller yon. Sasabihin niya lang, oops, sorry. Not my fault. Nagkaroon ng calamity. I'm supposed to deliver it. Hindi pa naman yun pero dahil nga bumagyo or nagka-calamity or diba kinain ng lupa dahil may earthquake, whatever. Due to fortuitous event, not my fault, I am not liable. Ganun lang yun. Diba? If the loss is through S's fault, he shall be liable to pay damages to B. Of course, kung may kasalanan, may damages. Again, sinabi ko yan kanina. If the car suffers damages without the fault of S, B shall have to suffer the impairment. So, kunyari, may bagyong dumating, hindi naman siya totally nasira, pero nagkagasgas siya kasi nadaganan ng kahoy dahil natumba yung kahoy or whatever. O, sabihin na lang ni B, oops, sorry, sa fault ng kahoy, it's an accident dahil may bagyo or whatever. So, the impairment of the car is not going to be my fault or it's not going to be at my expense. So, ikaw na bahala dyan, buyer. Ipaayos mo na lang. Okay? If the damage was due to S's fault, okay, B may choose between the rescission. Kung, halimbawa, nasira ni seller, okay, if nasira ni seller yung car, tapos si buyer ngayon, ang choice niya is, ayoko na yung car, pangit na siya, ayoko na yan. So, pag ganon, pwede niyang ipa-rescind yung contract, no? Cancel na lang, ayoko nang bilhin, yun ako magbabayad. Plus, magbabayad ka ng damages kasi I'm supposed to have the car today at meron akong delivery at gagamitin ko yung car. At dahil hindi ko siya magagamit, I will suffer a loss for the transaction that I have signed a deal with. So, pwede kitang habulin dyan. Okay? Plus damages. Okay? Or, pwede ko rin tanggapin yung car, tapos, of course, makiklaim ulit ako ng damages na, dahil kasalanan mo naman to, ipaayos mo to, at dahil ipapaayos pa yan, nagsuffer ako ng loss ng certain things na I'm supposed to use the car, at dahil pinapaayos pa nga siya today, I will also suffer damages, plus damages ulit. Okay? So, basta may fault, may damage. If the market value of the car is increased, halimbawa, biglang nagmahal ang mga ganitong model, kahit second hand, the increase shall inure to the benefit of B. Kay buyer na yon. okay, as he suffers the deterioration in case of fortuitous event. So marapat lamang na kapag nag-improve yung price, nag-increase yung price sa kanya din. If the seller had the car painted, paano kung pinaganda talaga ni seller, no? And his cover seat, change at his expense. Ay, ito luma na rin itong cover seat, palitan ko din. Gumasto siya. He shall have the rights to avert refractory with respect to the improvements. Sabi ni batas, sabi ng law, okay lang, ipagandahin mo yan at your expense, pero you will not be entitled to reimbursement. The only benefit that you will get is habang nasa iyo pa yung property or yung car, nagagamit mo siya na maganda na siya. Di ba? Maganda na yung cover seat, maganda na yung paint niya. Diba? Sikat na sikat ka na kahit hindi ko maganda na yung car mo, kahit hindi naman na pala sa iyo dahil naibenta mo na. Pero that's your usufructuary rights over the thing sold before its delivery. Upon delivery, wala kang entitlement to reimbursement for the emoluments or increase in the value or improvements to the property that you already sold. Okay? Okay, how about 1539? The obligation to deliver the thing sold includes that placing in the control of the vendee all that is mentioned in the contract. Okay? So, ano yung napag-usapan? Entire area stated in the contract must be delivered. If the sale of a real estate should be made with a statement of its area at the rate of a certain price per unit of measure or number, the cost of the contract with respect to the vendee is the number of such units. Or if you wish, the thing purchased as determined by the stipulated number of units. The vendor must deliver the entire property agreed upon. When the entire area could not be delivered, if all that is included within the stipulated boundaries is not delivered, then the object of the contract, its cost as far as the vendor is concerned, is not delivered. Hence, again, pwede niyang ipa-cancel dahil parang nag-deliver ng kulang. Okay? He may, however, enforce the contract with the corresponding decrease in price. Kung talagang kulang at interesado ka pa rin naman, kahit kulang na, interesado ka pa rin, then go ahead. Pero, syempre, there should be reduction in the price as agreed upon. Kasi sabi mo, oy, hindi naman na ito yung pinag-usapan. So, dapat medyo babaan na lang natin yung bayad. Okay? When vendee is entitled to rescind sale of real property, kailan ba? Okay? Under the above article, the right of rescission is available to the vendee in the following cases. 1. If the lock-in area is at least 1/10, then that stated 10% lang, di ba? 10% mentioned must be based on the area stipulated in the contract and lot. Kahit 10% lang ang kulang, pwede ko nang ipa-rescind. Ganun. If the deficiency in the quality specified in the contract exceeds 1/10 of the price agreed upon. Okay? Yung quality naman, okay, it's more than 10% din. Ay, naku, ang discrepancy. Rescind contract. Okay? If the vendee would not have brought the immovable had he known of its smaller area or inferior quality irrespective of the extent of the lock-in area or quality. Okay? What is under 1540? If in the case of the preceding article, there is a greater area or number in the immovable than that stated in the contract, ano mangyayari kay buyer kung mas malaki pala? The vendee may accept the area included in the contract and reject the rest na, ito na yung pinag-usapan, so whatever yung sobra, go ahead, kunin mo yan. Pwedeng ganun yung pag-action mo. If he accepts the whole area, kung yung buo talaga ang bibilin mo, of course, you will pay, okay, the contract rate. Where immovable of a greater area or number, okay, if the area or number is, okay, ito yung sinabi ko kanina, the vendee may not withdraw from the contract. Kung greater in number, okay, if hindi ka pwedeng mag-withdraw na, ay, mas malaki pala yan, ayoko na lang. No. You can choose to just accept whatever is stipulated in the contract, whatever remains, you can just reject. Okay? But if you accept the whole area of the property, you must pay the price. Okay? 1541, the provisions of the two preceding articles shall apply to judicial sales. Okay? So, in judicial sales, the same rule shall be applied when two or more immovables are sold for a single price. But if besides mentioning the boundaries, which is indispensable in every conveyance of real estate, its area or number should be designated in the contract, the vendor shall be bound to deliver all that is included within said boundaries, even when it exceeds the area or number specified in the contract. And should he not be able to do so, he shall suffer a reduction in the price in proportion to what is lacking in the area or number, unless the contract is rescinded because the vendee does not accede to the failure to deliver what has been stipulated. Okay, so mistake in area stated in the contract is immaterial. If the sale is made for a lump sum and not so much per unit or of measure or number, the cost of the contract is the thing sold independent and irrespective of its number or measure. Yung parang sinabi niya, oh, itong buong area na to, mga around 6 or 7 hectares, na hindi siya sure. Kung halimbawa, it's shy of 7 hectares, it's immaterial kasi yung buong area naman ang binibenta. It's a specific property in the area. Kaya halimbawa, yun lang naman ang pagmamayari niya, tapos sabihin niya, binibenta ko sa'yo yung property ko dyan sa Grand Europa. Tapos dyan sa Grand Europa pala, isa lang yung property niya. Mga around ganitong square meters or ganitong ano. So, the discrepancy is a bit immaterial. Where area or number stated together with boundaries. If the vendor cannot deliver to the vendee all that is included within the boundaries mentioned in the contract, the latter has the option to reduce the price in proportion to the deficiency. Kung kulang. Okay? The phrase should he not be able to do so refers to a situation when the vendor, either because a part or parcel of the real estate does not belong to him or cannot deliver all that is included within the boundaries. No, mali pala siya din ng estimate o hindi niya alam, di pala niya pagmamayari yung buo or whatever. Then marireduce yung price talaga of the real estate that was supposed to be sold. Okay, let's look at an example. F sold to B a parcel of land for the lump sum amount of 300,000. Okay? The contract states that the area is 500 square meters. Subsequently, it was asserted that the area included within the boundaries is really 600 square meters. In this case, the seller is about to deliver all the 600 square meters which are included within said boundaries without increase in price. Okay? If S does not deliver, kasi nga, hindi naman siya specific to the square meters. It was the parcel of land, the lump parcel of land. If S does not deliver also the extra 100 square meters, B has the right to rescind the contract or pay a proportionately reduced price, namely, kung ganitong presyuhan, 5 over 6, diba? 500 over 600. 5 over 6 of the original price or 250,000. Okay, divide mo yung 300,000 by 6, that's 50,000. So deduct 50,000 from the 300,000, that's 250,000. Or you can just type in your calculator 5 over 6 times 300,000, you should get 250,000. Okay? Okay. Conflict between area stated and boundaries. Where boundaries given are sufficiently certain, the proposition of law is to effect that where it appears that the land is so described by boundaries as to put its identification beyond doubt. An erroneous statement relative to the area of the questioned parcel may be disregarded because what really defines a piece of ground is not the area mentioned in its description, but the boundaries therein laid down as enclosed in the land and indicating its limits. Where boundaries do not identify land or overlapping of boundaries exists. Okay, so the above rule is not applicable where the boundaries relied upon do not identify the land beyond doubt. In a case, the deed of sale did not even indicate with particularity the area of the land covered thereby, the parties merely pointed at boundaries which were even beyond what could have been bought by the vendee. Hindi klaro. Or where the discrepancy in measurement is so great. In a case where petitioner claimed in his application to be entitled for registration of a parcel of land whose area after the survey turned out to be 626 hectares, while the grant given to him only mentions 92 hectares, the court rejected the claim, ruling that when the land sought to be registered is almost 7 times as much, grabe naman to, di ba? As much as that described in the deed, the evidence as to natural boundaries must be very clear and convincing before that rule. That natural boundaries will prevail over area can be applied. Okay, so hindi naman pwede yung masyadong malaki yung discrepancy. Is so great yung sinasabi. biruin mo 626 hectares pala yun kiniklaim niya, tapos 92 lang pala nandun sa letter of the contract. So parang ang layo naman, di ba? So 1543, prescription of actions. The actions based on 1539 and 1542 for either rescission of the contract or proportionate reduction of the price must be brought within 6 months counted from the day of delivery. So, kung hindi mo siya na-actionan within 6 months, hindi mo na pwedeng i-impose o enforce yung rights na yon. In 1544, in 1544, if the same thing should have been sold to different vendees, the ownership shall be transferred to the person who may have first taken possession thereof in good faith, if it should be movable property. Should it be movable property, the ownership shall belong to the person acquiring it, who in good faith first recorded it in the registry of property. Mula naman siyang kamalay-malay at pina-register niya. Should there be no inscription, the ownership shall pertain to the person who in good faith was first in the possession, and in the absence thereof, to the person who presents the oldest title, provided there is good faith. Napaka ng good faith na yan, no? Wala kang knowledge of defect. If the property is sold by the vendor, okay, preference of ownership, ito na, preference of ownership, sino makiklaim, okay? The conflicting rights of said vendees shall be resolved in accordance with the following rules. Una, if the property sold is movable, the ownership shall be acquired by the vendee who first takes possession in good faith. So, kung yung naunang nakakuha, sorry na lang yung ibang nakabili na hindi nila angkin. Okay? Who first takes possession. Remember, who first takes possession. Again, who first takes possession. So, let's say for example, si A, binenta niya kay B, kay C, kay D ang the same item. Tapos, una niyang binentahan si B. Tapos, after 3 days, binenta niya rin kay C. Tapos, after 3 days, binenta niya rin kay D. Okay, the question is, who will be the owner? Okay, who will take, if the property is sold, okay, movable siya, who will have ownership? Who will be the owner? Okay, tanungin mo, sinong unang nakakuha ng item? Kung kahit na unang nakabili si B, pero unang nakuha ni D, or unang nakuha ni E, or unang nakuha ni C, sino yung nakakuha na una, first takes possession, shall be deemed the owner. As long as yung possession niya is in good faith. Okay? Nung pagkakuha niya ng thing in good faith, meaning, okay, binili din niya. Without the knowledge na binili din pala yun ng, example, kung si D ang nakakuha, hindi niya alam na binili din pala yun ni B at ni C. So, siya yung magiging owner, or the ownership belongs to D, the one who first takes possession. If the property sold is immovable, okay, the ownership shall belong in order of registry in good faith. So, ibig sabihin, kung sino yung unang nakapagparehistro nung property, as if he or she has actually bought it first, diba? Kasi hindi naman niya matatransfer kung merong mga encumbrances or merong mga other provisions in the property na naka-attach, no? So, kung naparegister niya na, wala ka ng choice, paregister niya na Kahit siya pa yung third buyer. Okay? So, the first who registered. The taking of possession of the property sold may be in any of the ways provided in Article 1497 and 1501. Who first took possession is equivalent to tradition, real or symbolic. Tradition, remember, tradition, the delivery is equivalent to tradition, real or symbolic, such as that which is acquired by the execution of public instrument. Thus, after the sale of realty by means of public instrument, the vendor who resells it to another does not transmit anything to the second vendee, and if the latter, by virtue of this second sale, takes material possession of the thing, he does it as mere detainer, and it would be unjust to protect this detention as against the rights to the thing lawfully acquired by the first vendee. Okay? So, registration of the immovable sold. So if sale merely presented for registration, the mere presentation to the office of the Register of Deeds of a document on which acknowledgement of receipts is written is not equivalent to registration. Registration in its juridical aspect must be understood as the entry made in a book or public registry of deeds. Okay? Nasa registry of deeds talaga siya. Sale registered in bad faith. Okay, Article 1544 does not declare void a deed of sale registered in bad faith. It does not mean, however, that said contract is not void. Okay, so specifically provides who shall be the owner in case of a double sale of an immovable property. To give full effect to this provision, the status of two contracts must be determined and clarified. One contract must be declared valid so that one vendee may exercise all rights of an owner, while the other contract must be declared void to cut all of its rights which may arise from the said contract. So, dapat ma-determine muna, okay, or i-determine dyan kung alin ang talaga ang valid. Okay? So, issuance of transfer of certificate of title, noted, not noted, an original certificate of title. In a case, it appears that the issuance of a transfer certificate of title to the first buyers was never noted on the original certificate of title which was not cancelled at all. Kasi pagka nag-convey ng property, dapat ino-note dun sa original certificate of title that it has already been transferred. That gives notice to everyone else that this property has now been transferred to a new transfer certificate of title. Okay, it gives notice to the public na, hey, this original certificate of title is now already transferred. It was held that the second buyers acquired ownership over the disputed lot since they were the first to register in good faith their sale in the registry of property. Kasi supposedly, yung original certificate of title has already been cancelled had it been transferred properly. So kung in the case na double sale, yung first buyer hindi niya napa-register, si second buyer nagpa-register siya, in good faith din, kahit siya yung first buyer, pwede niyang i-claim kasi na, oh, ako yung nauna, so dapat any sale after my purchase should be void, di ba? Hindi, kasi sabi ng batas, whoever said buyer who registers first. Okay? Ikaw yung naunang bumili pero hindi mo na pa annotate, hindi mo na pa note. Okay, not noted on the original certificate of title. And therefore, si second buyer has no notice na meron palang ibang nakabili ng property. And he was even able to obtain another certificate of title. So, he is in possession and is in good faith. So, ayon, kahit na-transfer na, may transfer certificate of title si first buyer, kung hindi naman niya napanote yung original at hindi naman na-cancel yung original certificate of title, si second, especially if the second buyer was able to acquire ownership over the disputed property by registering first in good faith. No? So, yan. Bantayan nyo rin yan. Yung circumstances in the case, kung bibigay. Immovable, registered, not registered. So, in second and third paragraphs, covers all kinds of immovables, including land, makes no distinction as to whether the immovable is registered or not. But insofar as registered land is concerned, the rule is perfect accord with Section 508 of the Land Registration Law of Act 496, which provides that no deed, mortgage, lease, or other voluntary instrument, except a will purporting to convey or affect registered land, shall take effect as a conveyance or bind the land until its registration. Ibig sabihin, hindi enough na meron kang deed of absolute sale. It shall take effect, the conveyance shall take effect until its registration. Okay? Property attached while still registered in the name of judgment debtor. A sale of real estate, whether made as a result of a private transaction or of a foreclosure or execution sale, becomes legally effective against third persons only from the date of its registration. Underline mo yan. Registration. Consequently, where the property was actually attached and levied upon a time when said property stood in the official records of the Registry of Deeds as still owned by and registered in the name of the judgment debtor, the attachment, levy, and subsequent execution sale made in favor of the judgment creditor transferred to him all the rights of the judgment debtor in the said property, unaffected by any prior transfer or an encumbrance not so recorded therein. Okay? How about unregistered property sold at execution sale was previously sold by judgment debtor? Ito maganda. Pina-attach, nagkakaso, pina-attach ang property. Tapos sinasabi, okay, it will be granted to the judgment creditor after the case. Inabenta na pala yun ni debtor. A sale of unregistered land which has not been registered in the Office of Register of Deeds is valid and binding as between the parties themselves. Sa kanila lang, between them. Okay? Notice of adverse claim was registered previous to sale to possessor. Since the owner's copy of the certificate of title was not delivered in due time to the first buyer, despite the promise by the seller to deliver the same in a few days, the buyer registered with the Register of Deeds on September 6, 1982, his notice of adverse claim as vendee over the property sold. The second sale was registered only on November 11, 1982. This is a good example, whereby a new title was issued in favor of the second buyer. Dalawang sale. The first buyer has a superior right to the property in question. Under Article 1544, it is clear that a prior right is accorded to the vendee who first recorded his right in good faith over an immovable property. Ano yung problema dun sa first buyer? Sa first buyer, the owner's copy of the certificate of title was not delivered in due time. Tapos, na-register ulit November 11, 1982, second sale. Ang may title nito is the first buyer kasi si first buyer napa-register naman niya. Hindi nga lang niya nakuha yung certificate of title. Okay? Pero napa-register niya. Ang sabi ng Article 1444, for immovable property, it should be the first to register. Ang first to register pa rin naman is the first buyer. Okay? Hindi naman sinabi doon na first to possess certificate of title. Okay? First to register ang sinabi doon. Okay? How about sale of was registered before the execution sale but after its levy? Okay, so the doctrine is that a levy on execution duly registered takes preference over a prior unregistered sale. And that even if the prior unregistered sale is subsequently registered before the sale on execution, but after the levy was duly made, the validity of the execution sale should be maintained because it retroacted to the date of the levy. This rule applies by analogy as regards encumbrances made after the registration of the levy of on execution. The reason, therefore, is that if the rule were otherwise, the preference enjoyed by the levy on execution in a case would be meaningless and illusory. So in short, the priority enjoyed by the levy on execution extends with full force and effects to the buyer at the auction sale conducted by virtue of such levy. Magre-retroact siya. Okay? Requirement of good faith. Okay. So mere registration of sale, not enough. Good faith is an essential requisite of registration to acquire new title. Because public records cannot be converted into instruments of fraud and oppression by one who secures an inscription thereon in bad faith. Okay? Purchase must be for valuable consideration. It is not only required that the purchaser of real property who has registered the same should have done so in good faith, but also for a valuable consideration. Thus, a purchaser in good faith is defined as one who buys property of another without notice that some other person has right to or interest in such property and pays a full and fair price for the same at the time of such purchase or before he has notice of the claim or interest of some other person in the property. Okay, of course, it should be obvious to you kung binibenta sa'yo ng napakamura, di ba? Parang hindi talaga good faith din in your end. Okay, but it's actually tricky and it has to be judged or it has to be, sometimes the court must intervene, especially in the determination, no? Whether really there is good faith or not. Continuation of good faith. The mere fact that the second contract of sale was perfected in good faith is not sufficient if, before the title passes, the second vendee acquires knowledge of the first transaction. So sana hindi mo muna ma-discover na merong defect yung title mo bago pa na-effect yung registration, di ba? Kasi pagka na-pass na yung title, kahit may knowledge ka na ng defect, okay na yon. Pero kung at the time na hindi pa na-pass yung title, pero na-perfect na yung contract, pwede pa rin yon, hindi ka pa rin, kasi kailangan yung continuation of good faith. The good faith or innocence of the posterior vendee needs to continue until his contract ripens into ownership. Okay? Kailangan muna talaga ma-transfer, ma-register. Okay? Burden of proof, good faith is always presumed. Okay? Yan ang maganda. Naniniwala po tayo sa kabutihan ng bawat tao. Okay? Good faith is always presumed. It is upon those who allege the bad faith on the part of the possessor rests the burden of proof. But the burden of proving the status of one as a purchaser in good faith and for value lies upon him who asserts that status were the seller and none to transmit to the purchaser, and the other claimant is himself a purchaser in good faith from the successor in interest of the original title holder. In discharging that burden, it is not enough to invoke the ordinary or legal presumption of good faith, that everyone is presumed to act in good faith. The good faith that is essential here is an integral part with a very status which must be proved. So, dapat wala masyadong irregularity in your purchase. Parang, sabihin mo, in good faith ako, wala pa talaga akong knowledge, pero hindi ka lang man lang nagtaka. Hindi ka man lang nagtaka na bakit binibenta sa'yo ng rush ng di ba? Napakamura, and then all other irregularities, in-ignore mo, tapos sasabihin mo na, in good faith ka. So, dapat, all the other surrounding circumstances will also prove that you are in good faith. Or at least would tell that you are in good faith. So good faith, bad faith, a question of intention. Okay? Good faith or the want of, it is not a visible, tangible fact that can be seen or touched, but rather a state or condition of mind which can only be judged by actual or fancied tokens or signs. Bad faith does not simply connote bad judgment or negligence. It imputes a dishonest purpose. Okay, basta bad faith. Some moral obliquity and conscious doing of a wrong. Okay? So, parang sinasabi dito, example, kung if it's common knowledge in the area that someone has bought the property, tapos in-ignore mo, tapos sabihin mo lang, hindi ko na naman alam na someone has bought this property, pero in effect, you really know that someone else may have already purchased the property. Maybe you're already acting in bad faith, no? Moral obliquity and conscious doing of a wrong. Property purchased already peaceable, possessed by another. A purchaser cannot close his eyes to facts which should put a reasonable man upon his guard and then claim that he acted in good faith under the belief that there was no defect in the title of the vendor. Okay? Yung sinasabi na, alangan naman sabi mo, sige, pikit mata na lang ako. Hindi ko titingnan yan para hindi ma-destroy yung good faith ko. Diyos ko. Diba? So, huwag kang magpakabulag-bulagan. Okay? Yung sinasabi niya. Thus, the vendee who purchased property which is already peaceably possessed by another without inquiring into the status of the property. Example, sabi mo, bibiling ko itong property na to. Sabihin ng seller, wala namang ibang nakabili niyan. Pero nung pagpunta nyo sa property, may ibang nakatira. Tapos in-ignore mo lang, pipikit ka lang. It's okay. As if hindi ko siya nakita. No, hindi pwede yan. Okay? Or the vendor's title thereto takes the risks and losses consequential to such failure. He is required to go beyond the certificate of title and make inquiries concerning the rights of the actual possessor. Yung parang you make your own due diligence din. Okay? Purchaser with notice of right of repurchase which has already elapsed. So similarly, one who buys property with notice that it is subject to right of repurchase from his vendor, although such right has already elapsed and there is no annotation of any repurchase by the vendor a retro, but the title has not yet been cleared of encumbrance without looking into the right of redemption inscribed on the title cannot be said to be a purchaser in good faith. Kung parang sinasabi dito na meron kasing vendor a retro, so meron siya right that this property can be purchased again by the vendor, by the seller, previous seller. Tapos bibilin mo siya sa new seller, which is the buyer previously. Sasabihin niya na okay na to, nag-lapse naman na yung time, hindi niya na pwedeng i-claim. Pero tinignan mo yung title, may encumbrance pa yun ng vendor a retro. Hindi pa na-clear yung encumbrance. Hindi pa siya na-delete dun sa title. Hindi pa siya natanggal. Patanggal mo muna bago mo bayaran kasi hindi safe yun. And you will not be called and you're not safe to be called a purchaser of good faith. Kung alam na alam mo at nakita mo dun sa titulo na merong encumbrance. Even if the encumbrance period has already elapsed. Basta nandun pa yon, ipatanggal mo talaga siya. Okay? Adverse claim previously annotated on the title of property sold. A subsequent sale of land cannot prevail over an annotated adverse claim which was previously annotated in the certificate of title of the property. A prior judicial determination of the validity of the adverse claim before it can flaw the title of subsequent transfers is not required. A contrary rule contradicts the very essence of adverse claims. The annotation of an adverse claim is a measure designed to protect, again, the interest of a person over a piece of real property and serves as a notice and warning to third parties dealing with said property that someone is claiming an interest in the same or has a better right than the registered owner thereof. So, kapag daw bumibili ka ng property for you to be a purchaser in good faith, of course, tingnan mo rin yung titulo kung meron bang encumbrance. May nakalagay ba doon na meron bang nakalagay doon na encumbrance or someone else has owned it or someone else has a title over it na mortgage ba yun? Baka naging collateral yun at yun ay nakaregister. Okay, so may mga annotation yun. Yung sinasabi sa annotation. It will be contained. So kung naka-annotate yan, ibig sabihin, in case of default of the debtor, yung property na yun, i-foreclose yun, di ba? Tapos, in a public sale or public auction sale, and the proceeds will be paid, it will be used to pay off the debt. So kung meron yung provision na yun, nandun sa titulo, may encumbrance, wag mo bilhin. Unless, of course, you're willing to take the risk that later on, marirescind yung contract of sale mo between you and the seller. Kasi, nag-lie pala si seller. Nagsinungaling siya sa'yo, di ba? So, it's important for you to also, again, make your own due diligence. Because remember, in the eyes of the law, the annotation serves as a notice and warning to third parties dealing with said property that someone is claiming an interest in the same or has better right than the registered owner thereof. Baka kasi sinasabi nung naging collateral na yun kung sakasakali naman kasi babawiin yung lupain na yun. Hindi niya pwedeng ibibenta yun basta-basta. He or she cannot convey it. And that is the very essence of the annotation. That is the very essence of the annotation. Kasi nga, I gave you, kung nung pinautang din naman yung taong na yun, yung prospective seller, nung pinautang naman siya at kinolateral niya yung lupain, yung immovable property, there was an agreement na kapag hindi ka nakabayad, yung lupain ang magiging pambayad. Diba? Mga ganun. So, bantayan mo yan. Adverse claim previously annotated on the title of property sold. Nangyayari talaga yan. Okay? Next is purchaser examined only the latest certificate of title. Okay, so in order that a purchaser may be considered as a purchaser in good faith, it is enough that he examines the latest certificate of title. He is not bound by the original certificate of title but only by the certificate of title of the person from whom he purchased the property. Good faith is presumed. So, of course naman kung mga 10 na rin, buyer, bago na ibenta sa'yo, Diyos ko naman kung i-require ng batas na ibalikan mo talaga yung original. It is enough for you to just examine the latest certificate of title. Okay na, okay, so this is the latest certificate of title. So, good faith is presumed. Kung tinignan mo naman yung certificate of title, wala namang encumbrance, and then you paid the fair price, di ba? Reasonable price, then you will be considered purchaser in good faith. Okay, other rulings on application of rules. Contract to sell or promise to sell in 1544 is applicable not only to a contract of sale but also to a contract to sell because the civil law, where tradition is necessary for the transfer of ownership, there is no real distinction between a contract of sale and a contract to sell. It has been held, however, that the provision does not apply to a case where there was a sale to one party of the land itself while the other contract was a mere promise to sell. Iba yung promise to sell and contract to sell the land, or at most an actual assignment of the right to repurchase the same land. There is no double sale of the same land in this case. Kung promise to sell is different from contract to sell. Donation, it applies to donations. Okay, a deed of donation executed with all the formalities of the law is on the same footing as a deed of sale in the form of a public instrument. So halimbawa daw yung isa deed of donation, yung isa contract of sale. Dalawa talaga yung conflicting kasi yung donation has a weight as if it is also a contract of sale. So again, babalik tayo dun sa rules. 'Di ba? Other rules, application of rules. Other rulings on application of rules. So kapag hindi mo pwedeng sabihin na, ay, ako talaga ang talagang may-ari nito kasi sa kanya donation, sa akin talaga sale. No, both are valid. So tingnan natin, sino bang unang nag-register? Okay, because as if, kung nauna yung donation, as if it's a double sale. Di ba? Kasi nga, in this provision, a deed of donation executed with all the formalities of the law is on the same footing as a deed of sale. Okay? Yung sa number 1 naman, yung conflict doon is contract to sell and promise to sell. Ang contract to sell is the same as contract of sale daw, but not the promise to sell. So kung promise to sell lang, walang double sale yan. Pero kung merong contract to sell and then merong contract of sale, merong double sale yon. Again, mag-a-apply yung who did the first registration in good faith. Buyer in good faith. Again, yung good faith is necessary. So, subsequent mortgage registered under Article 3344, an unrecorded sale of a house of a prior date is preferred to a recorded mortgage of the same house of a latter date for the reason that if the original owner had parted with his ownership of the thing sold, then he no longer had the ownership and full disposal of the thing so as to be able to mortgage it. Okay? So an unrecorded sale of house of a prior date is preferred to a recorded mortgage of the same house of a latter date. For the reason that if the original owner had parted with his ownership of the thing sold, he no longer had the ownership and full disposal to mortgage it. So, ito sa case ng number 3, between a contract of sale unrecorded at saka yung mortgage, sino na yung magpiprevail? Magpiprevail yung contract of sale. Kasi yung mortgage, void na yon dahil wala naman in the first place na right si mortgagor, okay, of the property kasi wala naman na siyang imo-mortgage, na ibenta niya na yon. Okay, subsequent mortgage of land registered under the torrent system registered by mortgagee. Okay, so let's look at an example. In a case, Z, after selling his land to M under a contract to sell, which sale was not registered, mortgaged the same property to GSIS. Pagkagaling, no? Which registered the mortgage and acquired the property as the highest bidder in the extrajudicial foreclosure sale. The registered right of GSIS as mortgagee of the property was held inferior to the unregistered right of M. The previous buyer, the unrecorded sale between M as the vendee and Z, the original owner, is preferred for the reason that if Z had parted with his ownership of the land sold, then he no longer have ownership and free disposal of the same so as to be able to mortgage it. Parang wala ka naman ng karapatang i-mortgage yun in the first place dahil naibenta mo na. So, you will not be in equal footing sa akin, GSIS. Sabi ni M. Ako yung nauna. Okay? So, si Z talaga, of course, alam natin si Z ay tarantado dahil naibenta niya na minortgage niya pa. Okay? But in this case, you should know that the title of the mortgagee, GSIS, is inferior. Okay? Mas mababa doon sa title ni M, who was the buyer. Okay? In a sale. Although si GSIS kasi dito, sa sale din naman niya na-acquire, but in a foreclosure sale, pursuant to the mortgage, di ba? So, ito, again, it should be clear to you that registered mortgage versus an unrecorded contract to sell, the contract to sell will prevail. Okay? Sale of unregistered land, a bona fide purchaser of a registered land at an execution sale acquires a good title as against a prior transferee if such transfer was unrecorded. However, if the land is unregistered, a different rule applies under Article 3344. Under Act 3344, registration of documents affecting unregistered land is without prejudice to a third party with a better right. The quoted phrase has been held to mean that the mere registration of a sale in one's favor does not give him any right over the land if the vendor was not anymore the owner of the land, having previously sold the same to somebody else, even if the earlier sale was unrecorded. Kung unregistered ka naman kasi yung land. Okay? What if sale to different vendees? Okay, clearly Article 1544 applies to a situation where the same property is sold to different vendees. Double sale. There must be at least 2 deeds of sale over the same property. It is not applicable where there is only one sale. Thus, in a case, although the deed of extrajudicial partition, which merely mentioned the alleged sale in favor of the petitioners of the subject property, was registered, while the pacto de retro sale in favor of private respondents was not, but the alleged deed of sale was never offered in evidence by the petitioners, it was held that registration did not operate as a registration of the deed of sale because, insofar as third persons are concerned, what could validly transfer or convey the vendee's right to the property to petitioners was the deed of sale and not the deed of extrajudicial partition, which only mentioned the sale. Pacto de retro sale. It is not applicable to a case which involves an earlier pacto de retro sale of an unregistered land and subsequent donation thereof by the vendor a retro to another who in turn sold it to a third party while the property was still in the possession of the buyer a retro or vendee a retro who had already acquired title before the donation because of the failure of the vendor a retro to repurchase the same. There being no title to the property which the vendor a retro could convey to the supposed donee, since he was no longer the owner thereof, no title could be conveyed by the donee by the sale of the property. How about contract of sale fictitious or forged or seller without right to sell? Ito maganda, wala talaga siyang right, no? Fictitious or forged, seller without right to sell. Binenta niya ang hindi sa kanya. Kagaling, no? It does not apply if the contract of sale first registered is fictitious or forged, or if the vendor is not owner of the property sold and had no right to sell the same. But a forged deed of sale of registered land can legally be the root of a valid title when an innocent purchaser for value intervenes. A deed of sale executed by an impostor without authority of the owner of the land sold is nullity, and registration will not validate what otherwise is an invalid document. However, the certificate of title was already transferred from the name of the true owner to the forger, and while it remains that way, the land is subsequently sold to an innocent purchaser. The vendee has the right to rely upon what appears in the certificate, and in the absence of anything to excite suspicion, is under no obligation to look beyond the certificate and investigate the title of the vendor appearing on the face of the said certificate. The remedy of the true owner is to bring an action for damages against the one who caused or employed the fraud, and if the latter is insolvent, an action against the treasurer of the Philippines may be filed for the recovery of damages against the assurance fund. Nagets niyo ba to? Kung ang rule is, kung ang nagbenta ay hindi naman siya authorized to sell, of course, the contract of sale is void. Null and void. However, dito kasi it furthers yung sitwasyon na nabenta siya, okay, the forger has obtained a new certificate of title, mayroong contract, 'di ba? Tapos I don't know how he was able to do it. Nakakuha siya ng transfer certificate of title. So ngayon, his name really appears there to be the owner. Tapos meron purchaser in good faith, binili niya dun sa forger. Yung new purchaser in good faith acquires a good title to the property. Why? He's a purchaser in good faith. Sabi nga natin kanina, Diyos ko naman, hindi ko naman naniimbestigahan kung kanino talaga nang galing. Where is the original certificate of title? I am only bound to examine the latest certificate of title. If this certificate of title says that it is clean, there is no encumbrance, no mortgages, no annotation here, I am not required under the law to look beyond the certificate of title. And then I bought this, and then I actually effected the sale, and then applied, and then registered. I am now the new owner of this property. O di ngayon, ang tanong mo, ano mangyayari dun sa original owner, sir? Kawawa naman siya. Hindi niya alam na ibenta na pala yung property niya. Well, in that case, the action of the original owner is to file a claim against whom? Against the forger. Ngayon, kung hindi na makapagbayad yung forger, malamang wala na yung pera kasi nagbenta na nga ng lupa na finorge niya, di ba? Oh. So, nabenta niya na din. So, wala na. Hindi na insolvent na. Sino doon kakasuhan? Si Treasurer of the Philippines, okay? Maybe filed for the recovery of damages against the assurance fund. Kasi, bakit nga naman hindi na-notice ni Registry of Deeds, ni government, na forged yun? Diba? Oh. So, hindi mo magiging kasalanan kung ikaw si purchaser in good faith. Diba tricky? Exciting. What if sale of property to one party and assignment of right to the property to another? The provisions of paragraph 3, article 1544, okay? To article 1544, obligations of the vendor, delivery of the thing sold in, okay? Sales does not apply to a case where the sale in favor of one party was property itself, while the transaction is in favor of another was a mere promise to assign, or at most an actual assignment of the right to repurchase the same. So kung assignment of the right to repurchase is same, it's not the same as the sale of the property itself. So hindi siya applicable, no? Sale of property subject to of contract to sell, conditional sale to a third person. In a contract to sell, there being no previous sale of the property, a third person buying such property, despite the fulfillment of the suspensive condition, such as the full payment of the purchase price, for instance, cannot be deemed a buyer in bad faith, and the prospective buyer cannot seek the relief of reconveyance of the property. There is no double sale in such case. Title to the property will transfer to the buyer after registration, because there is no defect in the owner-seller's title per se. But the latter, of course, may be sued for damages by the intending buyer. Siyempre, kung ikaw si intending buyer, okay, pwede ka rin talaga mag-seek ng damages against the seller. Tanga-tanga to si seller. Contract mo pa sa akin, meron parang contract to sell, di ba? O meron parang, conditional sale. Okay? So that's it, guys, for today's topics. Any question?